So the Muslim, whenever he does a good deed, he has to have the sincere intention for the sake of Allah to get reward for that good deed. The reward is defined as the compensation that the Muslim receives in the hereafter for the good deeds that he did in this life among what makes him happy. An example of the reward that is guaranteed to the righteous Muslim in the grave is that the grave is expanded approximately 105 feet by 105 feet, and the grave is illuminated with a light similar to the light of the full moon, and the fragrance of paradise will be present in the grave. The sincere intention means for the Muslim to do the good deed, seeking the acceptance of Allah only, and not the praise of the people. So alhamdulillah, we are grateful to Allah that we have been guided to Al-Islam, because Islam is the only true religion. Islam is the only valid religion. Islam is the only religion accepted by the Creator of the universe. As is evidenced in the Quran, إِنَّ الدِّينَ عِنْدَ اللَّهِ الْإِسْلَامِ, which means indeed the only accepted religion to Allah is Al-Islam. And in another ayah from Surah Al-Imran, وَمَنْ يَبْتَغِ غَيْرَ الْإِسْلَامِ دِينًا فَلَنْ يُقْبَلَ مِنْهُ وَهُوَ فِي الْآخِرَةِ مِنَ الْخَاسِرِينَ. And we are grateful to Allah that we have the knowledge of Ahlus Sunnati wal Jama'ah, which is the saved group. Just as the Prophet ﷺ mentioned in the hadith of the 73 sects, that he said, my nation shall split up into 73 groups. All of them will be in hellfire except for one. And when he asked who that one was, he said, Al-Jama'ah, which means the congregation, and in another narration, As-Sawadul A'zam, which means the vast majority, and in another narration, Ma ana alayhi wa ashabi. So these three narrations put together, they let us know that the criteria by which we judge if someone is on the saved group is by the numbers, yani by being the majority, and their sign and their indication is that they have the same creed as the Prophet ﷺ and the companions. So an example of that, and a way that we can put this rule into application, is we say, if you ask the people who identify as Muslims and you ask them, who was the first rightful caliph? The majority of them will say Abu Bakr as-Siddiq, and only a minority among them will say that it was supposed to be Al-Imam Ali radiyallahu anhu. So you would know that they are not upon Ahlus Sunnati wal Jama'ah, that they are not the saved group. So we're going to continue on with explaining the Matan of Abi Shuja', which is a beginner's book in the Shafi'i school of Islamic law that is very famous and widespread. Many students of Islamic knowledge that they study the Shafi'i school of Islamic law, they take this book when they are starting off. And so we're going to recap what we mentioned before when we were talking about the bayyina, which is the evidence. We said that if the plaintiff, the one who's making the claim, if he has a bayyina, which in this case, it means the witnesses. So either he has two trustworthy men, or one trustworthy man and two women, or four women, or one trustworthy witness with swearing, and with what is called al-yamin, which is that they swear by Allah and in a certain way, confirming or negating a certain thing, which we'll mention. So we said that when the plaintiff makes the claim, and so he hears that testimony, and he would judge according to the one who has the testimony, if he knows, the judge himself, if he knows that those witnesses, that they are trustworthy. And we're gonna, the trustworthiness, or the chapter about the witness himself and the conditions is gonna come. So it is known from this that the one who has the right, he does not take it upon himself to get his right. Rather, he has to take the matter to the Muslim judge or to someone that acts in his place in what is valid for him to do that. And he is not allowed to take the right on his own if he fears that there will be a harm from that. Otherwise, he is religiously allowed to take that right on his own. So this is what we mentioned before, that let's say if you were in the street, let's say, and you were riding your animal, your camel or your horse, or let's say in this case your car, and there was that Islamic infrastructure where there is a Muslim judge, and so another Muslim robbed your car. So in this case, if you go and try to take it back by force on your own, and you try to take your property back, if it leads to a harm, then the person, he has to go to the Muslim judge. But if he doesn't fear a harm, then he takes it, and without going to the Muslim judge. So that's one of the cases that we mentioned. Then we mentioned the case where, let's say, one Muslim owes another Muslim money, or someone owes you money, and they are able to pay it, and they're refusing to pay it. So someone owes you money, and they're able to pay it, and they're refusing to pay it. So in this case, when that's the case, then the person who is owed the money, he is allowed to take what is owed, and what is owed to him. He is allowed to take what is owed to him. So let's say someone owed you $1,000. They have that money, but they're refusing to pay it. So you're allowed to take $1,000 from that person. By coming across it, or taking it. And so if he does take the $1,000, then that's it. Once he takes the $1,000, they become in his possession just by him taking it. And he doesn't require a statement of, I now own this, in order for it to become his property. Now, if he's not able to get that exact amount, like he gets a larger amount or something other than that is not, let's say, $1,000. If he is able to get, let's say, $5,000, he gets that, and then he gives the extra amount back. Or if he's not able to get the actual money, he can, and he gets something that, let's say, is of value, then he sells it on his own, and he then gives the extra, and after he gets his right, he gives the extra back to the one who he took that right from. And he would do that in a way where the person is unbeknownst to him. So either, and he gives it to him as a gift, he says, here, I got this gift for you, or he puts it back in the place where his stuff is without him noticing, etc. And we mentioned also that in this case, and in the case where he's able to do it on his own, he is allowed to do what makes him arrive to his right, like breaking a door or making a hole in the wall or tearing a cloth, and he does not have to pay anything to replace it. And this is the case with the condition that the thing that he is doing that to does not have anybody else's rights attached to it. So like, for example, he rented the owner of the house, for example, he rented the house to someone else. The one who is owed the money, he wants to go into that house and get what he's owed. So because in this case, the one who owes him the money rented the house to someone else, the one who has the right of the money, the one who is owed that money, he's not allowed to break that door because it's rented to someone else. So now it's tied to somebody else's right. And we also mentioned that, and also for this case, and in the case where that's allowed, the person, he has to be very cautious because these types of matters, especially nowadays, if the person gets involved in that, they can lead to consequences that are not praised. Then we also mentioned that in the case of the retribution through execution, like let's say somebody killed your family member and you're among the inheritors, and they killed them unjustly, on purpose, unjustly. So the judgment for that person, if they went through the Islamic court system, would be that if the heirs, if they agree that the killer should be executed, then the Muslim judge, then he applies that verdict to them. So let's say instead of that, before that happened, one of the heirs went and took it upon himself and killed the killer. So this is forbidden. He's not allowed to do that. He gets a sin for that, and he would be chastised by the Muslim judge for taking the matter into his own hands, kind of like overstepping those in authority. But the retribution would be enacted. It would be considered that the retribution has occurred. And we also mentioned that if the plaintiff, he does not have any witnesses, he doesn't have a bayyinah, or he has a witness but his testimony is not accepted, then the saying or the judgment would go to the defendant by him swearing, if the plaintiff demands it. So if the plaintiff does not demand it, then the Muslim judge does not order the defendant to swear. And so in the case where the defendant, where he swears, then this ends the conflict. So now, once the defendant swears, then according to the Muslim judge, now there's no more conflict anymore. However, the right of the plaintiff does not get voided. So if the plaintiff then later on, he does come with witnesses, then the Muslim judge would hear their testimony. And the defendant, because he swore, for example, that that whatever it is that's claimed against him is not correct, he would not be chastised because of the possibility that when he swore that he was forgetting. Now let's say that the plaintiff, the defendant, he refused to swear. So now we're talking about the plaintiff and the defendant. Neither of them have a witness. The plaintiff then says to the judge, make the defendant swear that, let's say, I don't owe him this money, or that he doesn't owe me this money. So then the Muslim judge goes to the defendant, he says, swear that you don't owe him this money. The defendant, if he refuses, if he refrains from swearing, the swear that is demanded of him, then the judge refers back to the plaintiff to swear. And so in that case, if the plaintiff, he swears, then the judgment goes to him. So if the plaintiff, once the swear goes back to him, the defendant refuses to swear, the judge now tells the plaintiff, do you swear And so he swears, yes, he owes me that money. So then whatever he swore about, it goes to him, and he deserves it. And he would not deserve it through the rejection of the defendant. So if the plaintiff does not swear when it's his turn without an excuse, then his right of swearing becomes voided because he turned away from it, not the claim. So if later he does get witnesses, then the Muslim judge, he hears it. However, if the plaintiff, he did not respond with the swearing, and after it was turned to him, if he didn't swear because of an excuse, like he wants to go ask an Islamic scholar a question referring to his case, or he wants to go back and review an account or some documentation so he can be sure about the swearing, then the Muslim judge would give him 3 days to do that. As for the rejection of the swearing, like when the Muslim judge, he tells the defendant, swear, for example, that you don't owe this person this money. If he says, I refuse, this is considered to be abstaining from swearing. Or if he says, the Muslim judge tells him swear, and then the defendant says, I don't swear, then this is regarded in the Islamic court as a refusal to swear. Or the Muslim judge tells him, say wallahi, and the defendant, instead of saying wallahi, he says warrahmani. It's considered to be that he refused to swear. Now, this is an explicit refusal of swearing. There's also something that is judged as refusal to swear, like when the Muslim judge tells the defendant to swear and the defendant remains quiet. He doesn't say anything. And not because he's bewildered, and not because he is, let's say, dull or slow to comprehend. He just, how they say here in this country, he pleads the fifth. And he just doesn't answer. So if he just doesn't answer, the Muslim judge considers that to be abstaining or a refusal to swear. Now, then we mentioned if the two opponents, if they both claim something, an entity, that one of them possesses, and neither of them have witnesses for that thing, then the judgment or the verdict would go to the one who has that thing along with his swearing, that the thing that's in his possession is his. Because having something in your possession is one of the causes that preponderate, the fact that that's the case. So we mentioned that, like for example, let's say you're living in a house, you're living in an apartment, and then somebody comes to the Muslim judge and he says, so-and-so, he's living in my house, that's my house. So the Muslim judge, he's going to summon you to the court, and you're living there. He's like, and you say, this is my house, I'm living there. So and neither of them have witnesses, so if the one who is living in the house, he swears that this is his house, then the Muslim judge judges in his favor. Now, if the matter or the thing that they both claim was in both of their possessions, like they both lived in the house, Allahu Akbar. How many times, who watches so-called Judge Judy? How many times have these things happened? They both live in the house, and he says it's my house, and the other one says it's his house, and one of them says he sold it to me, and the other one says I never sold it to him, or it's all types of craziness. But so if they're both living in it, and if, for example, like they're both living in the house, or they both claim that the car is theirs and they both use it, or they both claim that this carpet is theirs and they both sit on it, and neither of them have a witness, then each of them would swear with a negation of it being the property of the other. So in this case, they don't swear that it's mine, they swear that it's not the other person's. Now, if they both claim something that neither of them are in possession of it, like, let's say something that was thrown in the street, but they're not there at that spot, they're not there where that thing is, then they both swear that that thing is not the other's. And then, after that happens, that thing will be split in half between them. Now, if that entity was in a third party's possession, then the saying would go according to him, and the verdict would be based on him. So basically, if a third party is in his possession, then it goes back to the case of when something is in your possession and then you swear that it's yours, then the judge judges in his favor. طيب. I think that's a good enough review. Now we go to the we gotta mention the witnesses. And it's something I want to mention about the witnesses. This is very beneficial. Extra details. So now we're going to talk about the conditions for the witnesses. So the testimony, it is defined as informing about a right for someone else, upon someone else. So, for example, if I testify for a person, I'm testifying that person, that it's his right over the other person, over the defendant or the plaintiff, whoever it is I'm testifying for, with a specific phrase. So that's the definition. Informing about a right for someone else over another person with a specific phrase. And that specific phrase is ashhad, I testify. And some scholars of the Islamic law, they defined the testimony as informing about something with a specific phrasing. So this definition is broader. The definition of a right is more specific than the definition of a thing. So it doesn't have to be a right. So for example, like testifying that they saw the crescent of Ramadan. Now if the person that's giving the testimony, if instead of saying ashhad, which means I testify, instead he says I know or I'm sure, this does not suffice as testimony. The basis for this testimony, before the consensus, are verses of the Quran, among them, وَلَا تَكْتُمُوا الشَّهَادَةِ. So this is a command from Allah, that if the Muslim judge summons the person for testimony, that they have to testify. And among the ayat, the ayah from Surah Al-Baqarah, وَاسْتَشْهِدُوا شَهِيدَيْنِ مِنْ رِجَالِكُمْ فَإِنْ لَمْ يَكُونَا رَجُلَيْنِ فَرَجُلٌ وَامْرَأَتَانِ مِمَّنْ تَرْضَوْنَ مِنَ الشُّهَدَاءِ. So here's another order from Allah for us to have witnesses. And it says, 2 witnesses from your men. مِنْ رِجَالِكُمْ. So, just to give you an insight about how the fundamentals of the Islamic law, and so they said that in the Shafi'i school, so they said the term rijal, it excludes what? It excludes women, and it excludes children, or prepubescent boys, because they're not called the rijal, even if they were being close to being pubescent. And then the pronoun kum, rijalikum, your men, what does it exclude? It excludes the non-Muslims. So in the ayah it says, what means, and take as witnesses 2 witnesses among your men. Who's your men? Among the Muslim men. So that excludes women, it excludes the non-Muslims, and it excludes the prepubescent boys. Then it continues saying, and if there's not two men, then one man and two women, among whom you accept as witnesses. Yani among whom the people of virtue accept as witnesses. And it's going to come. And also there are hadiths also that are confirmed about this. So what are the components of a testimony? There are 5 components. The testifier, the witness, the thing that's being testified about, the thing that, or the one who is being testified for, the one who is being testified against, and the phrase, and the wording. So now, the author is going to say, the testimony to the judge is not accepted except from someone who has these conditions when that thing occurred. Or has these conditions when they testify, except in the specific scenarios where the trustworthiness or these conditions are a condition for them to be present when the thing occurred. So again, we're going to explain. First thing that I want to say about this is, when we say a claim like this, and referring to the technical definition of someone going to the Muslim judge or someone that's like the Muslim judge. And we mentioned before that the one who's like a Muslim judge is someone who is not an actual Muslim judge, but they have certain conditions, like they're trustworthy and they have a certain conditions. And then the two parties, right, that they want this judgment to go through, these two parties, they appoint that person, this trustworthy Muslim, they appoint him to act as a judge in their case. So the most common that is used these days is like for the woman who doesn't have a guardian for marriage. So the groom, the bride and the groom, they pick a trustworthy Muslim, a trustworthy male Muslim that fits the conditions to act as a judge, and then they appoint him as a judge. And so this can occur also with conflicts. So if one person says, this person owes me $1,000 and he's not paying it, and they go and appoint someone to be a judge in their matter, so then these rules would apply. And then whatever that person judges, that's the judgment that goes through. Except that in this case, when it's not a real Muslim judge, when it's someone that's appointed to be a Muslim judge, like to act as a Muslim judge, if one of them retracts his appointment, then that's it, it's retracted. But once that one who they appointed as a Muslim judge, once he judges, then the judgment goes through. He can't say after that, I don't accept it. So this is specific. That thing right there, that's specific to what? To the Muslim judge and to the one who is appointed as a Muslim judge. And in other than that, that rule doesn't apply. So for example, if somebody comes up to the Shaykh and they say to the Shaykh, oh Shaykh, so-and-so, Fulan, he owes me $1,000 and he's not paying them back, and he hasn't, he's not paying it back, and I have two witnesses, and the two witnesses come and testify, the two trustworthy witnesses, they come and testify to that Shaykh about it. What's that Shaykh gonna say? He's gonna give the judgment. Then that person is obligated to pay you, is obligated to give you the money. But it's not a hukum, judgment, it's not a verdict like how it would be in the Islamic court. Because in this case, it would just be a fatwa, a religious judgment, giving a religious judgment. So there you see the difference there. But anyway, so the testimony to the Muslim judge, or the one who's appointed as a Muslim judge, would not be accepted except from the one who these conditions are gathered in him when he is giving the testimony, even if they did not exist in the person when the thing that they're testifying about occurred, except those things which their validity depends on that person being with these conditions at the moment that it's done. Like the one who is a witness to a marriage contract. So in the Shafi'i school, the one who's a witness to the marriage contract, he has to have these conditions that we're going to mention. We're going to mention them. He has to have these conditions. If he didn't have these conditions when the contract was done, then the contract wouldn't be valid. So he has to have these conditions when the contract is done. Except that for the marriage contract, the trustworthiness that is taken into consideration is the apparent one. But in the other cases of testimony, when they're testifying to the Muslim judge, he has to take into consideration the internal trustworthiness, which is a trustworthiness that has been investigated and has been vouched for, and the Muslim judge, and he himself knows that that person is trustworthy. And we're going to mention the conditions. But let's say that so-and-so witnessed such and such person lend so-and-so $1,000. When he witnessed it, he wasn't trustworthy. He didn't have these conditions. But then when the conflict was brought to the Muslim judge and when it was time to testify, now he is trustworthy. He did satisfy the conditions. So if he testifies to what he witnessed back when he wasn't trustworthy, it still goes through. That's the point of that. That his trustworthiness or these conditions being fulfilled are taken into consideration when he's giving the testimony, and not necessarily when the thing that he witnessed occurred, except for those matters that the trustworthiness is required for that thing to be valid in the first place, like witnessing a marriage contract. So these conditions are 5. There are 5 things. One of them is al-Islam. So the author, the original author of the Matan, the original explainer of the Matan, Al-Ghazi, he wrote in his explanation, Al-Islam, even if it was through association, what is known as At-Taba'iyyah. And so it was erased because of its inconsistency, because it presents like a bewilderment or a puzzle. It doesn't fit. Why is that? Because the one who is judged as a Muslim by association would be the prepubescent boy or the person who's insane, and neither of them, their testimony is accepted. Because in order for the testimony to be accepted, you have to be sane and you have to be pubescent. So that's why the author of this copy, they erased that part from there. So among the conditions for the testimony to be accepted is al-Islam. Hence, the testimony is not accepted from a kafir for a Muslim or for a kafir. Allahu Akbar. So if a kafir testifies against a kafir, his testimony is not accepted. Or testifies for a kafir, the person who's testifying, if they're a kafir, their testimony is not accepted, whether it was related to Muslims or not related to Muslims. Allahu Akbar. And we see why. The scholars, they said, because the kafir, he lies about Allah. So it is not trusted that he would not lie about the creations. And we see that ourselves. There was recently a trial that was very famous, before the one that's really famous now. The YSL trial. So one of and this was filmed, like this was on social media, you could watch it. The main witness for the prosecution, that he had made a plea deal and everything, when they put him on the stand, he literally contradicted everything that he said. When they asked him the questions, like supposedly the testimony that's going to put this other person in jail, he was saying, nope. He was saying, I don't know. He was saying, no, I didn't say that. In some cases he said, I lied. So he definitely, or a mockery was made of that courtroom, but that shows you, something that occurred in the apparent, that is something that we know, even if it didn't occur in the apparent. And the proof that the testimony of the kafir in the court is not accepted is, among that is the verse from Surah At-Talaq, وَأَشْهِدُوا ذَوَيْ عَدْلٍ مِّنْكُمْ, which means, and take as witnesses those who are trustworthy among you. Minkum. Among who? Among the Muslims. And the kafir is not trustworthy, and he's not from us. So he doesn't fit either stipulation. The second condition is pubescence. Hence, the testimony is not accepted from a prepubescent boy, even if he was close to being pubescent. So let's say he didn't see any of the signs of pubescence, he did not see his semen, and he was like 13 years old, 14 years old, he's being close to pubescence, he's called a murahiq. Still his testimony is not accepted. Because of the ayah says, mir rijalikum, amongst your men, from your men. The third condition is the mind, hence the testimony is not accepted from the insane person by consensus. The fourth is freedom. So testimony is not accepted from a slave. The fifth is trustworthiness. So here we're going to go into some detail. What is trustworthiness? Trustworthiness is linguistically uprightness. Trustworthiness, al-hadala, linguistically is التوسط والتوسط معناه الاستقامة ليس كما يظن كثيرا من الناس أن يكون في النصف عندما نقول التوسط ليس معناه أن يكون مثلا يعني عنده شيء من هذا الطرف وشيء من هذا الطرف لا أن يكون في النصف في هذا الشيء لا بل المراد بالتوسط الاستقامة. So what's meant by, or the linguistic meaning of al-adala, trustworthiness, is uprightness. And religiously, in the religious context, it's an attribute in the self, an attribute that is ingrained within the person that prevents the person from engaging in enormous sins, even one, and prevents the person from being persistent in committing small sins without repenting to the extent that they exceed his good deeds, and that prevents him from engaging in what breaks his muru'ah. And what breaks his muru'ah, it means, what breaks his adherence to the manners of his pious peers. And there's a part where we explain that. There's a part that's coming where we explain that, inshallah. Because each of those things, and committing an enormous sin, even one, and being persistent in sinning without repentance until it exceeds one's good deeds, that's an enormous sin in itself. And not adhering to the virtues of the pious peers, to the etiquettes of the pious peers, all of these things, they make the person lose trust and confidence in the one who has them. And the people would not accept for that person to be a witness for his testimony. They would not accept his testimony. And also it's a condition for the testimony to be accepted that it be spoken, that it be uttered. Hence the testimony of the mute person is not accepted, even if he has understood gestures. Because somebody who's mute, what do? They speak sign language. So even if they spoke sign language, it wouldn't be accepted. And also, it's a condition for the testimony to be accepted that the person be aware, that the person has an awareness. Yani, not to be the type of person that they cannot define what is occurring in front of them. You know how sometimes people, they're, how do we say it? Dull, slow, dense. Something could be happening in front of them and they can't define what it is. So that it's a condition for the person not to be like that in order for the testimony to be accepted. And also for the testimony to be accepted, the person cannot be suspect. Hence the testimony is not accepted from someone who has an open enmity between him and the person he's testifying against, an open enmity. Because they're enemies. So of course he's going to testify against him. Or his testimony is sus. Now for the trustworthiness, there are 5 conditions. One of them is for the witness to avoid the enormous sins. That means each kind of enormous sins. So the testimony would not be accepted from someone who committed an enormous sin like fornication or killing unjustly or drinking alcohol or leaving out the prayer and other than that. Some Islamic scholars of the Islamic law, they define the enormous sin as the crime that makes the person feel, that gives the impression that that person has a weak religiosity and that that person doesn't take the religion as serious. And among the most clear definitions of the enormous sin is that which the one who does it would get punished by religious punishment, or a prescribed religious punishment, or the one who does that sin, it's said about that one, in the Quran or the Hadith, that they have a severe torture, or that they're damned, either by a verse of the Quran or a confirmed Hadith or the consensus. And that's the definition, and that's the most clear definition, and that's the definition that our Shaykh, rahimahullah, that he went by. The second condition for trustworthiness is for the person not to be persistent on doing small sins, even if they were even if they were not a large number of kind of sins. Like even if it was one type of small sin that they did persistently without repenting to the extent that it exceeded their good deeds, that takes them out of trustworthiness. And so in this case, we don't say that once their small sins exceed their good deeds, we don't say that those small sins disappear and that they transform into an enormous sin. No, that's not correct. What's meant is that those small sins, they remain, but now when his small sins, they exceed the number of his good deeds, that itself is an enormous sin. And the small sins are many. Among them is the forbidden look. Like looking at something that you're not allowed to look at is a small sin. Uncovering the unlawful nakedness, even if the person is alone without a need. That's a small sin. What is it called when you don't talk to someone? When you giving the Muslim the cold shoulder for more than 3 days without an excuse. That's a small sin. Small sin, yeah. Soiling yourself with najasa other than urine, without a need is a small sin. Because of course it's known that if you soil yourself with najasa, and if you contaminate yourself with najasa, with urine, that's an enormous sin. But contaminating yourself with najasa other than urine, without a need, is a small sin. Also, playing with dice, is a small sin. Listening to the forbidden instruments, the forbidden entertainment instruments, like the flute, like the guitar, and in all those variations. And the author mentioned here something that is not the most accurate, but he says like making an image of something that lives. So the correct thing is to say that making an image of something that lives is an enormous sin, not a small sin. That's the correct thing. And Nawawi, he rejected what some of the later Shafi'is said. He said, because of the severe threat of torture, إِنَّ أَشَدَّ النَّاسِ عَذَابًا الْمُصَوِّرُونَ, which is a confirmed hadith. Which means among the people who are most tortured are those who make images. And so that Sahih hadith, it includes that which has a shadow and that which doesn't have a shadow. So whether it was drawing on a piece of paper or sculpting a statue, it applies. So yeah, even if drawing something that lives, even if they don't draw the full body, even if they draw half of a body, this is forbidden. Then after it's drawn, the scholars, they said, if it's in a way that it cannot possibly live, like being half a body, for example, or like with the head off, then they said it's permissible to keep it. If somebody draws, let's say, half of a bird, this is haram. But since, let's say, a bird can't live with half of a body, then it's permissible to keep that image instead of, let's say, ripping it or throwing it away. Half the body. Because it's in a form that it can't live. In the Shafi'i. The three Imams, the three madhabs, they said that. Hanafi, Shafi'i, and Hanbali. The only one who said that it was permissible was Imam Malik, and only about the drawing that doesn't have a shadow, yani not a statue, not a sculpture. For the sculpture, this is forbidden by consensus. The third condition is for the person to have the correct creed. Hence, the testimony is not accepted from a heretic that his heresy or that his deviation in the creed leads to the extent of him becoming a kafir. Like the one who denies the resurrection, or the one who says that something other than Allah creates, or the one who says that Allah is a body, or the one who says that Allah is dwelling in a direction. So these people, their heresy, their deviation, their bid'ah in the creed led to the extent of blasphemy. Likewise, the one who denies an attribute amongst the 13 attributes of Allah, his testimony is not accepted. Just as the one who, they have a deviance, they have a bid'ah, an innovation in the creed, but it does not lead them, it is not to the extent of blasphemy. His testimony is not accepted if because of his bid'ah, his innovation in the creed, it led him to do an action that's an enormous sin, like the one who insults Abu Bakr and Umar radiyallahu anhuma. Because the reason that he insulted Abu Bakr and Umar is because of the deviation that he has in his creed. All of that detail except a group called Al-Khattabiyya. They are excluded from this amongst those that they have a deviance in their creed that did not reach to the level of blasphemy. They're excluded from this, yani that we say even them, and even though their situation didn't reach to the extent of blasphemy, we don't accept their testimony because it is part of their deviation in the creed that if someone from their sect testifies, then they automatically, or if someone from their sect makes a claim, then they automatically testify for that person just because it's them. They say that person wouldn't lie. So that's why their testimony would not be accepted. Now we're going to get to something important here. مبحث مهم. أساء بعض فهم كلام إمامنا الشافعي رضي الله عنه فظن أن الإمام لا يكفر أحدا من أهل البدع طالما هم ينفون الشريك عن الله ويصدقون بنبوة رسول الله صلى الله عليه وسلم وبنوا على ذلك عدم تكفير المجسم ولو أطلق على الله سبحانه الجسمية وهو مدرك لمعنى ذلك أي وهو يعتقد في الله تعالى الجهة والمكان والحيز والطول والعرض والعمق وغير ذلك من صفات الأجسام. So what we're reading here is an important note, an important topic. Some people have misunderstood, in a bad way. They understood in a bad way the speech of our Imam al-Shafi'i. And so they thought, they wrongly thought, that Al-Imam al-Shafi'i does not judge anyone that is a heretic as a non-Muslim, which is wrong, of course. They said as long as that person does not associate partners with Allah and they claim that they believe in the prophethood of Prophet Muhammad sallallahu alaihi wasallam. And of course that's incorrect. Al-Imam al-Shafi'i, he judges by the Quran, he judges by the Hadith, and he judges by the consensus. So he would not judge someone as a Muslim if they have a creed that is against Islam, if they have a creed that contradicts Islam. He wouldn't do that. But some people, they misunderstood what Ash-Shafi'i said, because Ash-Shafi'i basically, he said, I accept the testimony of the people, of the heretics, except one group. So they took that, they didn't understand it properly, and they took that and they said, oh, this means that Ash-Shafi'i, even if a person says that Allah is sitting on the throne, they say, according to Ash-Shafi'i, he judges him as a Muslim because if he did it, then he wouldn't accept their testimony. That was their bad reasoning. A heretic is someone who has a deviation in the creed. So someone who's not a Sunni Muslim. Someone who's not Ahlul Sunnah. So like the Wahhabis, like the Mu'tazila, like the Jahmiyyah, like the Karramiyya, like the Rafidah, and in all these misguided groups, and these are called Ahlul Bid'ah or Ahlul Ahwa. So they misunderstood the statement of Ash-Shafi'i when he said, I accept the testimony of the heretics except Al-Khattabiyya. So what Ash-Shafi'i meant by that, as is going to come, is, as long as there is not a case of kufr that has been confirmed about them. Meaning, if someone just says about themselves that they are Wahhabi, just by them saying that about themselves, without me, for example, without it being confirmed for me that they believe one of the blasphemous cases of Wahhabism, then I don't judge them as a kafir. Just the mere affiliation to a misguided group, that by itself does not make the person of a person that claims to be Muslim. They claim to be Muslim and they say about themselves, I'm Wahhabi. Or they say about themselves, I'm Salafi. Just by them saying that about themselves, we don't judge them as a kafir. We don't judge them as a kafir until we know that a specific case among the blasphemous cases that they believe, that it becomes confirmed for him. And so once we know about him, that he believes, for example, that Allah is sitting on the throne, or once we know about him that he believes that Allah moves up and down, or once we believe about him that he knows, once we know about him that he believes that Allah is located in a place, then we judge him as a kafir. Or if he knows what the Wahhabis believe, and he knows what their creed is, and on top of that he affiliates himself to them. But if he, just by him affiliating himself, that's not enough for us to judge him as a kafir, unless something becomes confirmed about him. Yeah, they wouldn't be a heretic because it's, exactly, they don't have a deviance in the creed. So they misunderstood the speech of Ash-Shafi'i, where he said, I accept the testimony of the heretics except Al-Khattabiyya. They said, oh, this means that Ash-Shafi'i doesn't judge any of them as kafirs, because if he did, then he wouldn't accept their testimony. And so they used that to say that the one who attributes a body to Allah is not a kafir, while knowing the meaning of the word body. So they took from that misunderstanding and they built upon it this incorrect judgment. Where they said that, oh, because the Shafi'i said that, that means that if a person says about Allah that he's a body, while knowing what the word means, that a Shafi'i doesn't judge him as a kafir, and so they said, we don't judge him as a kafir, a'udhu billah. And of course, a Shafi'i is innocent from that. And they said the same thing about the one who is a Mu'tazili, which is a misguided group, and they have blasphemous beliefs. Among them is that they negate the attributes of Allah. They say Allah is not attributed with knowledge. They say Allah is not attributed with speech. They say Allah is not attributed with will. This is blasphemy. It's strange. It's weird. No way that you're going to understand what they say. Just know that that's what they say. We're not putting words in their mouth. And that's blasphemy by consensus. Among the blasphemous things that they say, that the Mu'tazila, that they say, is that they say the slave creates his own actions. They say that Allah gave the creation the ability to create their own actions, which is kufr, of course, because it's explicit associating partners with Allah. And the Mu'tazila, they also say that when Allah gives the slave the power to create, that then Allah becomes incapable of doing anything with what that slave creates. Na'udhu billah. Yes, it's insane. It's insane. So there were people that misunderstood the speech of Ash-Shafi'i, and they put that the one who believes those things, like the Mu'tazila, they said that that person is not a kafir. Na'udhu billah. But of course, they're not someone who, and their statement would hold weight, because they're under the Imam and they're contradicting the Imam. So it continues on saying, وَمَنْ ظَنَّ ذَلِكَ مِنْ كَلَامِ الْإِمَامِ فَقَدْ أَبْعَدَ النُّجْعَةِ وَلَمْ يُصِبْ فَهْمَ كَلَامِهِ. يعني وَمَنْ ظَنَّ ذَلِكَ عَنِ الشَّافِعِ أَخْطَأَ خطأ عجيبا بعيدا غريبا. يعني أبعد النجعة، يعني ذهب بعيدا عن الصواب. كيف وقد نقل أساطين مذهبه عنه تكفير المجسم كما نقل ذلك عن غيره من الأئمة المجتهدين. يعني how could someone claim that Ash-Shafi'i does not judge the one who attributes a body to Allah as a kafir, when Ash-Shafi'i himself, he said, Al-Mujassimu kafir. And other imams amongst the mujtahid imams, they also documented that repeatedly. Just like the Salaf, they repeatedly documented that those who deny destiny and those who they say about Allah that those who say about Allah that He's not attributed with attributes and they deny destiny, the Salaf also documented that they are non-Muslims. So Al-Imam Al-Bulqini Al-Shafi'i, who is attributed with being a mujtahid himself, he said in the commentary of Ar-Rawdah, he said, وَقَوْلُ الشَّافِعِيِّ رَضِيَ اللَّهُ عَنْهُ أَقْبَلُ شَهَادَةَ أَهْلِ الْأَهْوَاءِ إِلَّا الْخَطَّابِيَّةِ محمول على من لم تثبت فيهم قضية معينة تقتضي تكفيرهم. انتهى. فيا من يدعي أنه من الشافعية، يا من يدعي أنه الشافعية الحقيقية أو الأصيلة، ماذا تفعل بقول البلقيني؟ So Al-Bulqini, who is a major figure in the Shafi'i school, and he was even attributed with being a mujtahid himself, he said in his commentary of Ar-Rawdah, he said, the saying of Ash-Shafi'i, I accept the testimony of the heretics except the Khattabiyya, means for someone that a specific blasphemous case has not been confirmed about him. End quote. So Ash-Shafi'i rahimahullah, what he meant is that the person who affiliates himself, for example, to the likes of the Wahhabis or the Mu'tazila or the like, Al-Imam Ash-Shafi'i would accept their testimony as long as it has not been confirmed about them a specific case that constitutes blasphemy, that he believes one of their blasphemous beliefs. And that is because among their innovations is what reaches to the extent of blasphemy, and among them is what does not reach to the extent of blasphemy. So as long as it is not verified for that individual that he believes one of their blasphemous sayings, then he is not judged as a blasphemer for the mere affiliation to one of those groups. And so he would accept his testimony as long as he fulfills the other conditions as well. As for if it is verified about him a blasphemous case that constitutes his blasphemy, then his testimony would not be accepted. And Al-Bulqini used as evidence for this that Ash-Shafi'i himself, when he debated a Mu'tazili named Hafs al-Fard, he at the end of the debate he said to him, لَقَدْ كَفَرْتَ بِاللَّهِ الْعَظِيمِ. قال البلقيني الصحيح أو الصواب أن قول الإمام الشافعي رضي الله عنه محمول على من لم يثبت عليه قضية معينة تقتضي كفره، وهذا نص عام وقد نص خاصا على تكفير من قال بخلق القرآن، والقول بالخاص هو المقدم. انتهى. هذا في أصول الفقه. فيا من يدعي أنه أصولي وأنه فقيه، ألم تعلم أن النص العام يتأخر عن النص الخاص؟ النص الخاص يقدم في الدلالة على العام. So what did Al-Bulqini say? He said, the correct thing is that the saying of Ash-Shafi'i radiyallahu anhu is to be understood and interpreted as though about someone who a specific blasphemous case has not been confirmed about him. And this is a general text, and he has given a specific text when he judged as a non-Muslim the one who claims that Allah is not attributed with the attribute of speech. And the saying that is specific is given precedence over the general statement. Subhanallah. So Shafi'i, he said about the Mu'tazili, he said, لَقَدْ كَفَرْتَ بِاللَّهِ الْعَظِيمِ. So that means that he judges him as a kafir, specifically. So that statement is given precedence in being used as evidence than the general statement, I do not, or the general statement, I accept the testimony of the heretics except the Khattabiyya. Subhanallah. And Allah Ta'ala knows best. There's more details to be mentioned, inshallah. We'll mention them next week.